Steve, a recent ruling by the Delaware court found that NYMEX's chairman and CEO did not breach their fiduciary duties in negotiating a sale to CME. Why was that ruling significant?
The ruling was significant because it reaffirmed the authority of boards to allow a CEO or a chairman in a transaction that doesn't involve a conflict, a transaction in which the CEO isn't getting something more than other shareholders on a pro rata basis, to represent the corporation, to negotiate on behalf of the corporation, to make decisions during the course of the negotiation.
This was a case where it was two strategics involved in the deal. When it's a private equity buyer, does that change the playing field at all?
It changes the playing field if the CEO, who's acting on behalf of the company, is going to stay with the company, if he's going to remain as the CEO, if he's going to remain as an executive, or if he's going to get a large block of stock in the new company, different than the amount that the other shareholder is going to get.
So in that kind of scenario, the board does the negotiating?
Well, it's an interesting question you're asking. It's impractical for boards to do negotiating. That's not what boards do. Often in this type of setting, you'll have a special committee of directors, and the special committee will have its own banker. And, there the outside directors have to be much more involved. And not just in the negotiation, the due diligence as well, which is a particular problem because who knows the company better than the CEO?
Exactly. So what is the state of play in terms of private equity transactions now?
Well, there aren't that many of the transactions. There are no firm rules other than the board of directors has to watch more carefully and be involved. Back in 04, 05, and 06, these issues were percolating through the courts, and if deals had continued at the pace they were continuing for 3 or 4 more years, there might well be more set rules now.